In the first video, I showed you of the various roadblocks that the GACHAGUA team would use in prolonging this case. Remember, their target is 3 years. I said that this hula baloo will take minimum of 6 weeks, maximum of 3 months. And I said that by Jamhuri Day, we will have a new vice president. Although, as we speak now, there is a restraining order restraining Professor Kithure Kindiki, Abraham Kithure Kindiki, from being sworn in as president. I want to correct myself. The injunction is barring Abraham Kithure Kindiki or any other person from being sworn in as president. Why am I emphasizing or any other person? It means that if they would not have placed that word or any other person, it would mean that those in authority would appoint JI-TENGE and pass through the steps in the National Assembly and whatever, and before you even know it, I'll be called Your Excellency. Yeah? So that is why they say, and any other person. On Thursday, the High Court is going to review, do they still extend the restraining order? The extension can be done in the following ways. The extension can be done sine die, or the sine die means in time indefinite, or most likely it can be done until the time a determination is made in this case. So it can be made, it can be stopped until the determination of this case, or they can refuse to extend it. If they refuse to extend it, two things are going to happen simultaneously and very fast. Now it matters who is faster than the other. Is the sound faster than light, or light faster than sound? One side of the debate would rush to go and prepare the installation. They'll rush, is it Uhuru Park or is it Uhuru Gardens? Anywhere. And then they'll rush and make sure that he's sworn in. And the other side will try to rush to the Court of Appeal, seeking restraining of that until the termination of the case. Now, if the case is passed, if the extension is if the extension is terminated, these people will try and swear in Kindiki as fast as possible, because the other side will go to the Court of Appeal to seek for the stopping of him being sworn in. Now, whoever will be faster, are they the ones who will be faster to obtain restraining orders, or will it be Kindiki and those supporting him who will be very fast to have him sworn in? Now, if they get the restraining order, because one of the people who will be restrained from is the Chief Justice, or in her absence, the Deputy Chief Justice, they will be restrained from witnessing the swearing in of the Deputy President. Remember, it would give a very bad picture if a high court or a court of appeal or even the Supreme Court stops the Chief Justice or the Deputy Chief Justice and they go and observe the swearing in. It will mean that they themselves have wamedharau mahakama, of which they are the head of the judiciary service. So any judicial department of whatever level making any court orders, the Chief Justice or the Deputy Chief Justice will agree. So as I said, that there is no restraining order, or once the time elapses and the court either decides to terminate it or even decides not to make any decision, because the restraining order is up to Thursday. Now, if it reaches a Thursday and they decide to terminate it or they make no decision, then Kindiki is free to be sworn in as early as Friday. But before he's sworn in, if the other ones do rush and have a restraining order, then it will stop until the case goes on. I repeated that for clarification, and for those of you who catch things earlier, please bear in mind that I belong to some of the people who like something repeated for emphasis. For emphasis. Now, today's episode, we wanted to talk about various ways of making a decision. Various ways of making a decision. What I've just said, I found it necessary to say because of the things that are happening. The things that are happening. I said, and I still repeat, that the shortest time that this hulabaloo can take is 6 weeks, and the longest is 3 months. But then if it reaches Thursday, and the court determines that they have no further restraining of Kindiki, he can be sworn in. And if they keep quiet, and either keep quiet or don't even make a decision or anything, then Kindiki's judgment, will have elapsed with time and he'll be sworn in and be the president. Now, what happens if the case will continue? Yes, Kindiki is sworn in as the deputy president and the cases still continue. Suppose the cases continue and Rigiji is found to have been wronged. Then the courts cannot order Kindiki to be stripped off and Rigiji no. It means that some of the things that have been decided against him, for example, being impeached, it means that forever. I don't know where some people are getting this idea of 10 years, but the Constitution does not talk of any time limit. It just says when you're impeached, you will not, unless we make a constitutional change and put there a time limit. It means that he cannot even stand to be for any public office, to be the cattle dip chairman. But if Kindiki is sworn in, and then it is found that he was unfairly sacked. Of course, there is the political price, because such things usually may even cost Ruto his presidency in the next election. But if it so happens, that is what I've said politically, but otherwise it means that Rigiji thinks that he's been barred for, people are saying 10, but there's nowhere they've written 10, for whatever time, because there is a silence on the period it is. It means that he's cleared and he can run later, either as a presidential candidate or a running mate or even a governor, an MP, all the way to the rank that I have, village cattle dip chairman. So he can run for those positions. The law would have allowed him. can run for any public office. And I've kept on saying that this episode wants to talk about the various ways on how these judges will make a decision. Usually the judges are odd number for an obvious reason, such that should they disagree, then there is no way they can come to an equal number. You'll find if there are 7 judges, it can be 6 versus 1, 5 versus 2, 4 versus 3. Yeah, that is what can come. But you'll find that there's a time when we had a Supreme Court when Justice Ibrahim was sick. So they were just forced to be 6. And you see, if they would have sat down, if like now there are 3, if one of them becomes sick, then the case is halfway. Nobody will come and replace him or her. The other 2 will continue until the case ends. And if the 2 disagree, because 2 is an even number, or if they are 5 and then they disagree on equally, that's they are 4, so it is 2-2. Or now there are 3, one of them for any reason, sickness or anything, or can even decide to abstain, or can decide to say that he or she has no decision to make. Then the other one say, for example, one says that Rigathi Gachagua was unfairly impeached, and the other one says he was fairly impeached. That is 1-1 draw. It means that no decision has been made. The decision by the lower people, in this case the legislature, means that it stands. Or if, for example, they are now in the High Court and they decide one way. If they decide that Gachagua was properly impeached, Gachagua will go to the Court of Appeal. And if they say that Gachagua was properly impeached, if they rule against Gachagua, Gachagua will go to court. If they rule against Ruto, Ruto will go to the Court of Appeal. And at the Court of Appeal, whatever decision that will be made, the losing side will still go to the Supreme Court. But in this case, when they're going to the Supreme Court, it will not be appeal. It will be for interpretation. That one I think I've covered. Now, how do they come out to make decisions? Once both sides have made their closing remark, then the judges will retire down for writing of judgment. They will privately meet, the 3 of them, and then decide among themselves which is the best way that they'll agree to make a judgment. They may even have made it. It's only that after the closing remark is when they'll say that this is how we have made. They can decide to sit together and make a judgment. They can decide each one to make his or her own judgment aside. Or they can give themselves time, because let's say they have given themselves 10 days. 10 days to make a judgment. And when they have decided 10 days, on the 7th day they meet. And then it will be a 5-minute meeting whereby they'll briefly tell each other. Each one will say, okay, me, I find the case has merit. The other one says, I don't have merit. It doesn't have merit. So when they've said that, if they find all of the 3 of them have agreed on one way or the other, then they may even decide to go and write a joint judgment. But they may sit down and you see it is an odd number. So they may sit down and decide that, for example, there are 3. So two are agreeing in one way. Let me not say which way. 2 are agreeing in one way and 1 is disagreeing with them. So when they have sat there, they have agreed, okay, two of you are saying this, then one is saying the other one. Then the two will ask, will agree among themselves. Do we write different judgment, or we write joint judgment? When they agree to write a joint judgment, then they will write a joint judgment. Now, in this case, I want to tell you that even though we have the presiding judge, but his voice is one among the three. He cannot say that since he's the chair, or like in the Supreme Court when we were hearing the presidential election, the Chief Justice will not say, I'm the Chief Justice, so whatever I say stands more than. That is just a judge like any other. It will be just a case of the Supreme Court, like the presidential case. How many judges? There are 7. Okay, how many agree? Now, let's say out of 7, let me try to be near. Let me not give 7. So, 6-1. No. Let me not even give 5-2. I'm giving 4-3. So if they are 4-3, and if they decide to have a joint, then the 3 will make a joint minority judgment. A joint minority judgment. And those who are 5, 4, 3 and 4, yeah, 3 and 4. The 4 will write a joint majority judgment. And when they are passing the judgment, the majority will start by reading the majority, whatever, and say that is. And then the minority will write the judgment where they have found that. But it will stand by as per the majority. Now, these are 3 bench church judgment. Najua uluya inaingia kidogo. When it comes to writing, let's say 1 agrees and 2 disagrees. Of course, the one who is saying ABCD will give his or her minority judgment. And these other 2, they will also agree whether to write a joint majority, or each will write his or hers. Now, a joint is very easy because it's a summary of the 2. But if they agree, that each one has to make individual decisions, then they'll go ahead. They will go ahead, and each one will read his or her judgment one by one, and so and so. So that I've tried to explain today how the judgment will be decided at any level. Like now, I don't want to repeat what I've said already. Like now, the present judgment, if they make a decision, let's say they may make 2-1, or they may make 3 of them, and then the losing side will appeal to the Court of Appeal. And you see, Court of Appeal, as I said, they must seat a higher number. And the higher number, they don't have other alternative. It will be 5. It will be 5 because the decision they make, especially where it touches on judicial constitution interpretation, it will mean that the case may go to the Supreme Court. And you see, the Supreme Court has 7 judges. This is what I'm trying to say. At the High Court, we have 3 judges. Then at the Court of Appeal, we have 5. And at the Supreme Court, we have 7. My viewers today, the intention was only to emphasize, or even to share with you about how judgment will be made among the judges in the High Court. The judges in the High Court, will they agree together? Not only the High Court, even the Court of Appeal and the Supreme Court. I hope you have understood me. Thank you.